Welcome to today's episode of the Flipped Classroom. Today I'm going to talk about legal classifications. Legal classifications are used to determine the degree of scrutiny or questioning that the Supreme Court gives to state and federal laws that limit the rights of groups of citizens, such as Latinos, women, or the poor. The Equal Protection Clause of the 14th Amendment has been interpreted to mean that state and federal laws cannot discriminate against groups of people. This principle, however, is not applied in the same way to all groups of people. Classification is a judicial creation. Through their decisions, the Supreme Court has created three classifications when judging whether a law violates the Equal Protection Clause of the 14th Amendment. This slide shows you just basic details about the three classifications. At the top, we have suspect classification. This is the most strict class, and it applies only to race cases. The next level is quasi-suspect classification, and it only applies to women. And at the bottom, where it's easiest for the government to prove that discrimination is necessary, is non-suspect classification, and that applies to groups such as age, wealth, and sexual orientation. Legal classifications were created by the Supreme Court to stress the importance of protecting Americans' fundamental rights. If you remember from last unit, the words fundamental rights were written in the Supreme Court decision Gitlow v. New York of 1925. This is the case where the idea of selective incorporation became valid by the Supreme Court. The most strict level of classification is called suspect classification. This was created by the Supreme Court in the Korematsu v. United States case. This was the case of Japanese Americans against the U.S. government. The U.S. government during World War II created Japanese internment camps. The U.S. government was concerned that Japanese Americans living in the United States might attack us during World War II. The court agreed with the United States government that there was a compelling state interest to relocate Japanese Americans from the West Coast to internment camps. And they used the following quote, in which you're going to hear strict scrutiny for the first time. They wrote, "All legal restrictions which curtail the civil rights of a single group are immediately suspect. That is not to say that all such restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism may not." The court is admitting that there are times when it is okay to take away people's rights, usually for government security. But they're saying there is no reason ever that they would justify taking away a person's right just because of racist beliefs. You will see a slide like this for all of the different classifications. For suspect classification, the standard of review is called strict scrutiny. This means that the court asks itself the question, is there a compelling state interest in this classification when trying to decide if a law that discriminates based on race should be constitutional? The government must prove that the discriminating law is essential to the safety and security of Americans. It is very unlikely that the Supreme Court will agree to any law that treats groups in this category differently. Minority groups want to be given suspect classification because it's much harder for state and local and national government to take away their rights by law. Currently, suspect classification is only granted to cases that apply to race. This slide shows two cases in which the Supreme Court used suspect classification to declare laws unconstitutional. The first is a case we're really familiar with, and that's the Brown v. Board decision of 1954. In this decision, the court said there was no compelling reason that segregation would help the state with education. The second case, Loving versus Virginia of 1967, was a case against a law in Virginia that made interracial marriage illegal. And in that case also, the Supreme Court declared that there's no compelling state reason for outlawing interracial marriage. The middle tier of classification is called quasi-suspect classification. The standard of review in this case is intermediate. The court asked the question, is there an important purpose for this classification? This is not as hard to prove as under suspect classification, where they asked, is there a compelling state interest? An important purpose is not the same thing as a compelling state interest. In this case, the court just has to prove that there is a good, valid reason for making a discriminatory law. And currently, quasi-suspect classification only applies to women. This slide gives you two court cases, one in which the court used quasi-suspect classification to uphold a law, and the second case where they used it to declare a law unconstitutional. The first case, Rosker versus Goldberg of 1981, is a really famous case where the court agreed with a law requiring men but not women to register for the draft. The court said there was an important purpose in this case to distinguish between men and women. And if you guys wonder why, this falls into at least what would be an old point of view, but probably agreed to by most people today, that men with their physical differences being stronger than women for the most part are better suited to being in the armed forces. The second case, Orr versus Orr, was a decision in 1979 that struck down a law that required men but not women to pay alimony after divorce. The Supreme Court said there's no government purpose that would be accomplished by making men pay alimony but not making women pay alimony. The placement of women in quasi-suspect classification is going to be an important idea for us during Monday's lecture. Many women have tried to achieve suspect classification in order to eliminate discrimination against them. So for many years, women would take cases to the Supreme Court in hopes that the Supreme Court would say, really, women should not be in quasi-suspect classification, but should be eligible for strict scrutiny. Other women, however, see some benefits to being in quasi-suspect classification, mainly when it comes to their childbearing years. Women can often get maternity leave. Nowadays, some men are getting paternity leave as well. But if they had to create only laws that required strict scrutiny to discriminate between men and women, some of those benefits that women get during those childbearing years to help them have jobs and a family at the same time might be ruled unconstitutional by the court. At the bottom of these categories of classification is non-suspect classification. The standard of review in this class is called minimum rationality, and you can tell just by the words that the court is going to be asking a lot less of the government as they defend the laws that they're making. The court will ask, is there a rational basis for this classification? By classification, it means by within the law classifying different groups of people. So the court will ask, does the government have a rational basis for making a law that treats a class of people differently? And if they can find any rational basis, then they will rule that the law is constitutional. So it's a lot more likely that state, local, national governments will win cases about their laws if it's dealing with a non-suspect group of people. This law applies to cases dealing with age, wealth, and sexual orientation. And because this class requires little proof on the part of the government, the LGBTQ community would really like to achieve a higher classification in order to protect themselves from discrimination. Again, I'm going to discuss two court cases The first in which the court upheld a law, and the second in which it struck down a law. In Gregory versus Ashcroft of 1991, the Supreme Court upheld a law requiring Missouri public officials to retire at age 70. And I'd assume in this case that the Missouri government proved that once officials got beyond the age 70, either they were sick more often, not showing up at work, or becoming senile, and so the government wasn't functioning as well. So in that case, there was a rational basis for discriminating by age. The second case, there's my cats again if you are listening. In the second case, Romer versus Evans of 1996, the court struck down a law an amendment that Colorado had created that banned legislation that would protect people's rights on the basis of sexual orientation. So what the amendment said is no locality in Colorado could make a law that said you could not discriminate against people because of their sexual orientation. Basically, if somebody was a gay or lesbian or one of those other categories, they could never be protected by law, leaving private companies to treat them, to service them or not service them as they chose. And the court said that they could see no legitimate state goal by creating this amendment, and so it was struck down. And to wrap up this presentation, I've included this chart that my lovely textbook that I call my baby had in it that I think is a really good place to reference. So you might take a cell phone picture of this chart or jot it down in your notes. I think it's a good place to go back to as you're studying, and especially like 6 months from now when you're studying for the AP test, you won't have to go all the way through this lecture again to get to this chart. And so this chart is looking at if the Supreme Court gets a case in which there is a law where people are classified, whether that's by race, gender, age, sexual orientation, I think there's another category that I'm missing, how will the Supreme Court proceed? And so if you look at the gray at the top, those are the series of questions the court will ask, going from left to right. So the first question they ask is, how does the government classify people in this law? So in the yellow line, they're classifying by race. And the Korematsu case is a good example of that. We were treating Japanese Americans differently than every other American. If they're discriminating based on race, then you must use suspect classification and use strict scrutiny standard of review. And those are the cases where you're asking, is there a compelling state interest in this classification? And the court is more likely than not, like almost all of the time, to strike down the law. It's very hard for the government to prove that there is a compelling state interest to treat one race differently than another. And quite frankly, if the Korematsu case was decided today, it would probably be struck down. Since the Korematsu case, as we get through the 1980s, 1990s, the national government has apologized to Japanese Americans and paid reparations to internees that are still alive. In it used to look orange, but maybe the brown row, that would be if the case is discriminating based on gender. In that case, we use a quasi-suspect classification and an intermediate standard of review. The court will ask, is there an important, not compelling, like necessary, but an important state purpose for the classification? Even with the quasi-suspect, though, it's unlikely that governments are going to win in the Supreme Court when they're discriminating based on gender. Finally, on the light gray at the bottom, we have the non-suspect classification. These are cases that discriminate based on somebody's age, their wealth, like laws that might apply to poor people differently than to rich, and sexual orientation. In these cases, a minimum rationality standard of review are necessary, And the government just has to prove there is some reasonable reason for the classification. It doesn't have to be important. It doesn't have to be compelling, but it has to be rational. In those cases, it's much more common for the government to win and for the law to be upheld. As a little bonus, I'm giving you a shot of Layla. This is a little girl who was eating my foot and my hand during the entire lecture. So I hope you enjoyed your lecture and your little Layla the super hellion moment.